hand down judgment in the matter of banks and the commissioners of Her Majesty's Revenue and Customs.
For the reasons given in the judgment which I am handing down, this appeal will be dismissed. The parties have agreed an order whereby the appellant will pay the respondents' costs of the appeal on the standard basis, but with the subject of detailed assessment, if not agreed, there is no application for permission to appeal to the Supreme Court.
Appeal in the matter of the joint administrators of LB Holdings, Intermediate 2 Limited, and Lehman Brothers Holdings, Scottish LP, and others. Part heard.
Yes, Mr. Phillips.
Good morning, my lords, my lady. My lords, I'm yielding to my learned friend, Mr. Beltrami, who wished to address your lordships in relation to the case that your lordship raised. In relation to an authority that your lordship
yes.
raised.
Yeah, I think it's
So I
a
yield
red,
to my
red
learned
herring
friend.
in the end, isn't it? Because it was a unilateral mistake.
Yes.
Yes.
Oh, that was going to be what I said about it. Well, thank you very much. My lords, my lady, we have now had the opportunity to read the transcript of Mr. Beltrami's submissions overnight and to consider some of your further questions that were raised. To do this in a structured way, I will adopt the same structure as the parties so far. So I will comment on the general approach, the amended notes, the unamended notes, and rectification. And I won't repeat the points that I made yesterday. Good. So if I may start with the general approach. Using my Lord Justice Lewison's words in our opening, the construction of each of the instruments requires approaching them as the reasonable reader would, giving effect to all the different parts of the agreement, reading them as a whole in a unitary manner and trying to avoid, where possible, an uncommercial result. Central to the construction arguments you have heard from both sides is the interrelationship between what we have called the definitional wording, which my learned friend calls the general principle or the statement of intent, and the conditionalities, which my learned friend called the mechanism. My learned friend repeatedly said that the real issue for your lordships is whether the conditionalities in these instruments amounted to an expression of juniority. And if you need the page references, it's on page 79, 23 to 25, 49, 23 to 25. We do not say that conditionality can never amount to an expression of juniority, but they don't in this case. All parts of the subordination provisions are connected by the word accordingly to the definitional wording, meaning in consequence of or therefore, and you cannot read one without the other. My learned friend, Mr. Beltrami, necessarily assumes that the conditionalities have independent and inconsistent effect to the definitional wording. My learned friend also said that the first phrase is just, and I'm quoting, a confirmation that the debt is subordinated debt, and he said that at page 35, lines 24 to 25, and he described it as, and I'm quoting, a general principle of subordination. And with respect, that is not right. That the statement is not an unqualified statement of subordination in the abstract. It is an agreement to subordinate one's rights to payment to defined senior liabilities or senior creditors. That is what the plain words say, and my learned friend's case in relation to the notes ignores it. I then turn to the amended notes. In asking you to find that the judge was correct for all purposes in relation to the amended notes, my learned friend Mr. Beltrami did not address two fundamental problems. First, on the judge's reasoning, the definition of senior creditors in the amended notes does not define to whom the LBHI2 subnotes are subordinated. Mr. Beltrami said that the conditionalities could alter the legal characteristics of defined senior creditors because those characteristics were not set in stone. with respect, we do not, we disagree. Take the amended notes. The definition of senior creditors expressly envisages debts which are junior because they express themselves to be junior. SLP3 has not agreed to subordinate its notes to debts expressed to rank junior to them. However, outside of a winding up, PLC say that no debt due can ever be junior because that is what the cash flow conditionality dictates. And inside a winding up, PLC says that all debt ranks senior to the notes, save the notional holders, because that's what the further conditionality dictates. In our submission, a reasonable reader would not conclude, having read the senior creditors' definitions, that the notes subordinated themselves to everyone, or almost everyone. Although my learned friend said by reference to the judge's methodology that it was uncomfortable, that was the word he used, to end up with potentially inconsistent subordination clauses, that is exactly where he ends up, with express definitions which are inconsistent with the conditionalities. And we don't think that your lordships will need authority for the proposition that where parties provide that certain terms in a contract bear a certain meaning when defined in a definitions clause, the court will be very slow in departing from the express meaning. And if your lordships wish to read T&N, paragraph 226 in the bundles is at authorities 128.523. I am not suggesting turning it up now. The second of these two fundamental problems is that on the judge's reasoning, the effect of what we call the further conditionality is that all upper tier 2 debts rank ahead of the lower tier 2 LBHI2 subnotes, save for the upper tier 2 debts that use the preference share mechanism. My learned friend could not explain why, on his construction, upper tier 2 debt ranked higher than lower tier 2 debt. That does not sit comfortably with GEMPRU. Your lordships will recall the letter Allen and Avery wrote confirming the LT2 status of the notes in both unamended and amended form, and as the judge found at paragraph 67, GEMPRU only required subordination to unsubordinated debts, both inside and outside a winding up. And your lordships will recall that the express subordination to unsubordinated creditors is found in the definitions. It is not found in the preference share mechanism. And my learned friend has identified no sensible regulatory reason as to why, on his construction, the subnotes were subordinated to absolutely everyone, including tiers of regulatory capital which sit below LT2. How did it make sense for it to be impossible for LBHI2 to issue junior regulatory debt at any time? Which is the flexibility, my lords, that your lordships have seen in Mr. Justice David Richards' judgment, in particular in relation to issuing further junior debt, which is excluded liabilities.
Can I just ask about tier 2 capital?
Yes.
That includes undated debt, I think, isn't it?
No, it's dated. Oh, it does include undated.
Undated.
So,
yeah.
On Mr. Beltrami's interpretation, the dated debt does take preference over undated upper tier 2 capital, doesn't it?
No, it doesn't. No. And that's one of the problems, because on Mr. Beltrami's construction, it only takes priority over such upper tier 2 debt if it uses a notional holders mechanism. And that was the judge's decision. And the way I think of it, picking up with my learned friend's Pink Floyd analogy, is that one has got the brick in the wall, preference shares, one's got the upper tier 2, one's got the lower tier 2, and further up one's got the seniors. So I can put 4 bricks, as it were, in the wall. But that's the answer to your Lordship's question.
So on Mr. Beltrami's construction, the notes take priority over some, but not all, LT2 capital.
Precisely right, my lord. Precisely right. And of course, the junior, any debts that express themselves to be junior, unless they use that same notional shareholder mechanism, are senior. Okay. Yeah. So, my lords, there are 6 specific points, if I may, in reply to the amended notes argument of made by my learned friend. The first point is what we describe as the floor, not a ceiling point. Mr. Beltrami said it was impossible and meaningless for there to be a floor but not a ceiling, and that is not right. The definitional wording defining who your senior creditors are sets the ceiling, and the ceiling below whom the amended notes rank. Interpreting the preference share mechanism as both a floor and a ceiling makes the definition of senior creditors entirely redundant, and one only makes sense of the whole clause on our case. The definitional wording tells you to whom you are subordinated, including, critically, the unsubordinated creditors, and the preference share mechanism describes the position in a winding up to make clear that this LT2 debt sits at LT2 level, above upper tier 2 debt. And in our submission, the repeated references to over and above are more consistent with the conditionality being a floor than it being a ceiling. And we made the point yesterday that the notional preference share cannot sit in the well-known place my learned friend described, because there are creditors in the brick immediately above, which is the upper tier 2 creditors. Second point, my learned friend's different regimes point. My learned friend, Mr. Beltrami, said it was not unusual to have different tests inside and outside an insolvency. He said that you get that from the LBHI2 sub-debts, the standard form, and you get it from the cases. 2 points. First of all, the LBHI2 sub-debts do not have 2 regimes operating inconsistently. That's not how they operate. Clause 5.1a is applicable outside a winding up. Clause 5.1b is applicable both inside and outside of an insolvency, and it affects subordination to the senior creditors in both scenarios. Second point, my learned friend referred to Maxwell and Kalkving. They do not support the different regime proposition. I won't go back to the cases, but your lordship should note that they are cases where there was only subordination in an insolvency. And that does not mean that the subordination provisions contain different regimes for where the debts ranked inside and outside of the insolvency. They were unsubordinated outside of an insolvency, and they had agreed to subordinate themselves inside an insolvency. So that's very different. The third point was the theoretical junior debt point. My learned friend, Mr. Beltrami, refers to the possibility of the notional holders and the potential for juniority. But he then said that there were no notional holders, and so the category below the debts is irrelevant. We say that that does not follow when one is looking at the construction, especially when you consider that the definition of senior creditors expressly contemplates debts that rank junior to the notes. I'm sure I don't need to remind your lordships of the words, but it does expressly contemplate there may be junior debts. And that language suggests that they do not fall to the bottom of the pile or join at the end of the queue, which is the submission that my learned friend was making. They expressly contemplate that there will be debts which are under express to be junior. The fourth point is the confirmatory note point. My learned friend, Mr. Beltrami, said we are bending the construction of the notes to the confirmatory note, and that is with respect to an unfair criticism. The notes sit in the lower tier 2 level above the equity and all the upper tier 2 debt, including preference shares and undated subordinated debt instruments. My learned friend also sought to explain the confirmatory note by suggesting that the reference to any upper tier 2 security was in fact only a reference to the notional holders. With respect, that construction is not open on the words of the confirmatory note. The wording states that the notes are intended to rank above any upper tier 2 securities, i.e. all upper tier 2 securities. In my learned friend's case, any upper tier 2 undated debt that subordinated itself without a preference share mechanism would rank above the notes. And the confirmatory note is inconsistent with that construction. Fifth point is the proving for 100%. My learned friend said that this means that the notes proved as a debt that ranked as a preference share. 2 points. That is impossible. It does not rank as a preference share because it is a debt. And the second point, it proves for 100%, which tells you that it can't be a share, but it also tells you it can't be a contingent debt. And it can't be a contingent debt because no contingent debt can prove for 100%. That would mean there's no contingency. And I know that my learned friend says this is an arid debate, but we do say that categorisation and characterisation of the mechanisms is important. Even on my learned friend's case, the further conditionality does appear to be a form of simple contractual subordination. Sixth point, the last point under this head, my learned friend did not attempt to justify the judge's analysis of the old and new regimes. In other words, the new regime being a completely different regime that starts with the conditionality, starting at phrase 8, but whether or not you've numbered it. Phrase 2, in other words, subordinated to the senior creditors, is where you find the subordination to unsubordinated creditors as required by GenPru. And that's the regulatory context of this debate. And it would be wrong to construe the subordination provision without reference to the clause that meets the regulatory requirement. And in our trial skeleton, just please make a note, at SB 1.8, 135 and following, we explain how...
SB 8?
SB 1, tab 8, 135 and following. What we've done there is an analysis of the regulatory regime, because of course you will appreciate that GenPru was the UK implementing the regulation. May I move on to the unamended, just a very few points. The unamended notes. The big criticism we raised of my learned friend's construction was that when applied, it left a very curious result under the definitional, that under the definitional wording, the notes rank after the senior creditors, as specifically defined, but under the solvency conditionality, they ranked behind all creditors. And my learned friend, with respect, had no answer to that point in his submissions. 4 specific points in reply. First of all, the tiebreaker point. My learned friend accepted that had the judge properly applied his approach to the notes on the definitional wording, you would reach at least a pari passu ranking with the debt. And that's at page 75, line 12 of the transcript. He said that the insolvency conditions were then the tiebreaker. He accepted that the sub-debt has a form of cash flow solvency condition, which is plainly right, we've seen it. The definition of liabilities is very broad. He said that you plug in the definitions, and I'm using my learned friend's phrase, plug in, and there is no expression of juniority. That was page 76, lines 3 to 7. He then turned to the notes. His argument was that when you come to the notes, you do not plug in the defined terms. You read the cash flow solvency in isolation, and that's what's supposed to make all the difference between the two solvency conditions. But if you don't plug in the definitions into the subdebt, why not? Sorry, if you plug in the definitions into the subdebt, why not plug them into the solvency condition in the notes? Why ignore the words accordingly and the connections to the definitional wording? These are all unanswered points on my learned friend's case. The next point is the two solvency conditions. In relation to the solvency condition in the notes, my learned friend said the end result is to ensure as much subordination as it could. With respect, that is not right. He only gets to that conclusion because he wrongly reads debts as meaning all debts and not just being debts owed to senior creditors, because he ignores the words as they fall due. And if my learned friend is right that the subnotes can be read in this way, and that was the correct exercise is to compare and contrast solvency conditions, then the same approach could be applied to the subdebt. If you read clause 5.2 in isolation from subordination to the senior liabilities, it requires you to pay all your liabilities. You could read it in the same way as the cash flow solvency condition to the notes, because any excluded liabilities with a solvency condition would not have fallen due. And there's nothing that might constitute subnotes and excluded liabilities in the sub-debt. Third point, my learned friend said it doesn't matter that there are two different solvency tests. A cash flow solvency test is referable to all debts, both senior and non-senior liabilities, and a balance sheet test that's referable to senior liabilities. With respect, that would create very odd results. Now, we agree with my Lord Justice Lewison that there are two limbs to the test. As we explained yesterday, when you look, for the debts as they fall due, it does not include the junior debts. And we disagree with my learned friend, Mr. Beltrami, that a cash flow test and a balance sheet test would ordinarily take as a relevant point of distinction the identity of the creditor in question. As the Supreme Court confirmed in Eurosale, the distinction is one of futurity concerning the debts in question. In other words, will it fall due in the reasonably near future? The fourth point is the parenthesis point. The words in parenthesis in the solvency definition relate to both. My learned friend said it would be strange that it qualifies both, but open to your lordships as a matter of construction. It's page 81, 16 to 17, and we say that is far more likely and gives effect to the definitional wording and treats the solvency condition as being in consequence of it, and is also consistent with debts as they fall due. The fifth point is my learned friend referred to a rogue junior instrument, which he said is not the answer to the meaning of condition 3 because it's hypothetical only. 3 subpoints, if I may. 1, we remind you of what Mr. Justice David Richards said about excluded liabilities in Waterfall 1. They are a category of potential liabilities, and they are still relevant to the construction exercise. 2, the important point to the reasonable reader would be that the note could rank above more junior creditors. And I'm sure that point's not lost on your lordships, which meant that they could not, at the same time, be rock bottom. And as I submitted to you yesterday, junior debt could not be a debt that's fallen due. If there was junior debt, it would not have fallen due, and the notes would rank for it. It follows from this that, contrary to my learned friend's submissions, the solvency condition is not an expression of juniority. And I want to make 3 points and then a final comment on the construction. 1, in the absence of an expression of juniority, it means that outside of winding up, the notes and the debt rank pari passu. 2, despite my learned friend's submission that you can have contrary and conflicting regimes in one subordination provision, a unified approach to construction points to the same relative ranking both inside and outside a winding up, you can have such an approach. Accordingly, to the extent that there is any ambiguity in relation to the new regime inside a winding up, it should be resolved in favour of a pari passu construction so that the two regimes are consistent. And then my final comment. My Lords, all of these instruments were part of the Lehman's regulatory capital structure. Your Lordships have heard my learned friend Mr. Beltrami alight on the reference to debts in the solvency condition in the subnotes, and say to your Lordships very eloquently, well, there it is, the expression of juniority. That is an expression that the notes say we rank junior to the debt. On a more detailed analysis, you discover that actually it isn't because it isn't, and my learned friend actually on a detailed analysis is wrong, because a junior debt will not fall due before a senior debt, and of course nor will a pari passu debt. But that's an example of my learned friends taking differences in the language used across these clauses and seeking to place on them a weight they do not bear. And you will shortly hear, your Lordships will shortly hear, my learned friend Miss Hilliard doing something similar with the pari passu wording in the PLC debt structure. But what your Lordships have not heard is a single reason why any of the Lehman's companies would have made any of the lower tier 2 debt, senior or junior, to any other lower tier 2 debt. And no reason has been given because there is none. The plain and obvious answer is that these tranches of subordinated debt ranked pari passu as between themselves. It is the only answer that makes any sense. And absent any clear expressions of juniority, that is what this subdebt did. My Lords, may I spend a very short time on rectification? Just a couple of points to close with on rectification, including an answer to your Lordship's question on clause 12. I will follow my learned friend's structure again, first dealing with the lack of evidence of intention from decision makers. My learned friend said the evidence was sparse, page 102, and that cases like SHC show you that rectification needs to be thrashed out in the witness box. That was at 106. Just a couple of points. As we explained to the judge at trial, and as my learned friend accepts, oral evidence is not a prerequisite for a rectification case, and your Lordships have seen Oscatello and Murray, which my learned friend referred to your Lordships. That was a rectification case which succeeded, and there was no oral evidence. And for your Lordships...
Well, I remember doing a case in front of Mr. Justice Lawrence Collins, which all turned on the agreement between two dead people, so there wasn't oral evidence to be pieced out from the documents.
Well, that's precisely the point, my Lord. I'm not overemphasising it, but that's the point.
It's a question of evidence.
Yes, exactly. There was a comprehensive disclosure of communications with the Lehman Group during the period of the amendments. There was, and thousands of documents, there was not a single document which showed any discussion of a relative ranking, let alone a change in relative ranking. And my learned friend showed you pages 100 to 101, which he suggested showed that other members of the Lehman Group, in his words, quoting, actively considering what the ranking position was pursuant to the amendments. He was looking at SB 241 at 520. This was obviously a discussion about retaining LT2 status and remaining as debt, not equity. In other words, a regulatory issue, not the relative ranking of the instruments. The ranking point wasn't raised because Mr. Grant didn't think there was an issue. And so he didn't tell Miss Dolby, and she said that she didn't raise it with those other people because the issue wasn't raised with her. And the inference from the lack of discussions on this topic in our submission, which is confirmed by Miss Dolby, was that there was no intention to alter ranking. My Lord Justice Lewison asked about the evidential basis surrounding Miss Dolby's statements that she shared her intention with Mr. Rush and Mr. Triolo, and your Lordship, that's page 116, 117. Can I just make a couple of points for clarification? Mr. Rush was the head of tax. He was Miss Dolby's boss and shared an office next to her. They discussed the amendments and the purpose of the transaction in the run-up to sign-off, and for your Lordship's note, again, Supplemental Bundle 2, 570, internal page 129.
I'm sorry, so that was supplemental bundle.
Number 2, tab 570, internal.
Tab 570.
That's why I was confused.
Yes,
Maybe
no,
page
no, no, no,
570,
page
I was looking at
570.
the-
Page 570, I do apologise, I've actually got a false reference. I
Fine.
apologise, I didn't notice.
I'm sorry, I put you off your stroke.
No, not at all.
That page shows discussions between Miss Dolby and Mr. Rush. Is that what you're saying?
Tab 54, my lady. Yes, they discussed the amendments and the purposes of the transaction in the run-up to sign.
Right.
That's what it goes to. Mr. Triolo was Vice President in the Tax Department. He was sent the electronic consent by Miss Dolby on the 28th of August. A gentleman named Mr. Guth, based in the US, asked for the electronic consent. He sent to Mr. Triolo, adding, just email the resolution to the directors and they will approve. And that, for your Lordship's reference, is SB1, tab 1, 317, which is in the 312. And those materials formed the background to the questions which I put to Miss Dolby about her sharing her intentions with Mr. Rush and Mr. Triolo. And I'm sure, my lords, you will recollect she did describe how she shared those intentions with them. And for your Lordship's reference, that is at page 571 of Supplemental Bundle 2, tab 54, sorry. And it was internal pages 135, line 19 to 137, line 4. And the point that I was putting to her was that there was no evidence that anyone considered relative ranking of the debt and the notes at the time of the amendment, because no one in the Lehman Group thought that they created a ranking issue. But that was shared between her and the individuals who signed the various resolutions. Can I just say something about Mr. Grant's intention, and then that will be it, apart from answering your Lordship's question. My learned friend referred to the intention of Mr. Grant. He did that at page 127. Can I be clear? It has never been part of our case that he was a decision maker. He was just the draftsman, but his evidence is useful in terms of, firstly, what he was instructed to do, secondly, the background to the drafting process itself, and specifically, my learned friend said that when Mr. Grant said he did not intend to change ranking, that was not so much, he said that was not so much the legal effect of the document. The best expression of what Mr. Grant was doing is in Supplemental Bundle 2 at tab 52.
Tab 52.
Tab 52, my lord.
Yeah.
552 internal pages 137 to 138. If your Lordships feel that I have time, I could show you now, if your Lordships would prefer to look at it later.
We'll look at it in our own time. So we'll look at it in our own time.
Thank you, my lord. Because what Mr. Grant says is that his intention was to make it clear that within the winding up, the securities continued to rank as above upper tier 2 security, whilst continuing to rank below the senior creditors. That's That's what one gets from it. And I think yesterday I did take your lordships back to paragraph 52 and pointed out my learned friend, in fact, hadn't read when Mr. Grant was referring to the ceiling. Mr. Grant, at the beginning of the paragraph, had referred to the definition of senior creditors. My lords, that leaves me with one point to deal with, which is your lordship's question in relation to whether the ranking alteration was within the scope of the power under clause 12. And I think I should just open up bundle 3, tab 41, at page 728, which is clause 12A. And if I can make the point before taking you to the language, this provides that any amendments to the notes can be made by extraordinary resolution, and it reserves certain matters which can only be amended by extraordinary resolution. So what it says, it's the first two lines. The procedures memorandum contains, and it's then provisions for convening meetings of note holders to consider matters in relation to the notes, and it's these words, including the modification by extraordinary resolution of any provision of these conditions. It then talks about the quorum.
Do we need to know anything about the procedures memorandum?
No, my lord. That's just the procedures for passing an extraordinary resolution. The point that your lordship asked me was, does
you say any conditions would include relative ranking?
Absolutely. And what, my lords, you see is that the provided, however, up to a reserved matter, identifies certain matters that can only be amended by extraordinary resolution. I'm not saying to your lordships the ranking is a reserved matter, but it does fall within any matter.
Yeah, and then you go on, presumably, to say a resolution in writing signed by all note holders takes effect as if it were.
As if it was. Precisely, my lord. It is a mechanism. It did apply. It could have applied. So the answer to your lordship's question, done properly, is yes. My lords, unless I can assist your lordships further, those were our replies to motions.
Thank you very much. Right, who's next? Miss Hilliard, I think.
Yes. My lady, my lords, the priority dispute here is between the PLC subdebts and the PLC subnotes. The PLC subdebts were 3 simple facility agreements with PLC as borrower and LB Holdings as lender, to which LBHI now has title by way of assignment. The investment structure that underpinned the issue of the PLC subnotes is more complicated, and for that reason it's deserving of some brief attention in order to understand the provenance of the subnotes. So first, GP1, the appellant. GP1 is the general partner of 5 limited partnerships, although we're only concerned here with limited partnerships 1 to 3. The limited partnership agreements for each of the limited partnerships are at bundle 4, 53, that's for the first limited partnership, 454 with a supplemental agreement, that at 455, that's in relation to the LP2, and the third limited partnership agreement is at 556.
I confess I haven't opened any of them.
No, well, I think I mean, move me on if you want to.
Well, if I need to look at them, of course I will. But I'm just telling you I haven't.
Yeah. Well, and that's why I think it probably does. You know, it is worth looking at them, not in a huge amount of detail, but I think it does help to put in context the particular construction issue which we're involved with. So the limited partnership agreements, they're dated the 22nd of March 2005.
Right, so we want bundle 4.
Yes, bundle 4 at tab 53 for LP1. We only really need to have a look at one limited partnership agreement because they're all in materially the same terms. So you have the general partner, LBGP number 1 Limited, Chase Nominees Limited, who is, we'll see, is the initial limited partner. LB Investment Holdings Limited as preferential limited partner, and then Lehman Brothers Holdings PLC as guarantor, and Lehman Brothers Holdings Inc., who we'll see is joined for the purposes of giving an undertaking that we'll look at in more detail as we go along. The LP1 agreement is actually at tab 53. So the recitals provide that whereas the general partner has agreed to become the general partner, the preferential limited partner has agreed to become a limited partner, and the initial limited partner, being a nominee for the common depository of Euroclear and Clearstream, has agreed, acting as principal, to become a limited partner in a limited partnership to be formed under the Limited Partnerships Act, in accordance with the terms and conditions set out in this agreement. And then you'll see that the guarantor and LBHI are not to become partners. Then you've got the definitions, and in particular you have Schedule 2. If one goes to Schedule 2 at page 1162, you have the definition of initial limited partner, which is Chase Nominees Limited. You have the definition of holder immediately above, which provides that in respect of each preferred security, each person registered on the register as the limited partner holding such preferred security. And then over the page at 1164, you have the preferred capital contribution, and that means in relation to the preferred securities, the aggregate contributions to the assets of the issuer being a whole multiple of €1,000 paid in cash by the holders. And then you have the preferred securities, the outstanding fixed rate to CMS linked, guaranteed, non-voting, non-cumulative, perpetual preferred securities of the issuer, originally issued on the closing date in the principal amount of €200 million, each such security representing an interest of a holder. So that is the ECAPs that stand behind the limited partnership. And then over the page, you have the definition of subordinated guarantee, which means the subordinated guarantee in respect of preferred securities executed by the guarantor. And that was the guarantee that was the subject of a consent order, whereby those with the benefit of the guarantee agreed that they were subordinated.
This is what the judge called Claim E.
Yes, exactly. And then subordinated notes means the fixed rate to CMS linked subordinated notes originally issued on the closing date in the principal amount of €200 million by UK Holding, that's PLC, and held by the issuer, that's GP1, as initial partnership assets, or any eligible investments which are held by the issuer as partnership assets thereafter. So if one goes back to page 1128, you have the commitment, which is defined as any amount of capital contributed to the issuer and any amount of capital agreed to be contributed by any partner to the assets of the issuer pursuant to clause 4. And then 1129, partner means general partner, the initial limited partner, so Chase Nominees, who are going to be holding the ECAPs, the preferential limited partner, or any other general partner of the issuer. And partnership assets means the assets of the issuer from time to time, and includes but is not limited to the name of the issuer, capital contributions, commitments, the subordinated notes, or any replacement eligible investments. And then over the page at clause 2, you have the formation of the issuer, and clause 2.4, 1131. The business of the issuer shall be to raise and provide finance and financial support to the guarantor, i.e. PLC, and its group in carrying on such business. The issuer shall do and acquire the following, acquire and hold subordinated notes. And then over the page you have the identification of the partners, who include the initial limited partner, and then we can move on to clause
Just
4.
in a couple of sentences, what are we getting out of this?
Well, my lord, I think what you're getting is at least that the design of the investment structure which supported the issue of the notes. Now, unlike the facility agreement between the LBHI2 subdebt, that here we have the subnotes that were purposely acquired by a limited partnership, and at the time, I mean, there was never ever any intention that these subnotes would be acquired by any other party other than, at the time, other than GP1 as the general partner of these different partnerships. And at the same time, there was a prospectus advertising the issue of ECAPs and effectively inviting third-party investors to invest in those ECAPs. So it was a complete. It wasn't entirely discrete to the Lehman group. There were outside investors that invested the ECAPs, knowing that the proceeds of the ECAPs would be used to purchase the subordinated notes.
Yes.
If one goes to clause 6, we can see the description of the preferred. Actually, if one goes to page 114, one sees
114 something. 114.
well, 1140, and one can see the reference to capital contributions, and clause 5.1b, the preferred capital contribution to satisfy the commitment in respect of the preferred securities referred to in 4.2 shall be €200 million, such sum to be paid by JP Morgan Chase Bank as common depository for Euroclear and Clearstream. So it's anticipated under the limited partnership that 200 million, which has been raised by issuing ECAPs to the market, will be paid into this limited partnership, which in turn will loan that monies or give those monies to PLC in return for the notes. And that, we say ultimately that may not make a difference, because we say that what you do is you simply construe the two separate instruments.
Well, that's what I would have thought, which is why I'm a little bit puzzled about what this is all about.
Well, I could have just ignored the structure, the investment structure, but in view of what my lady said at the beginning of the appeal, that made it clear that you hadn't even had an opportunity to look at the documents, I thought it wasn't, uninteresting or irrelevant that you saw them, so that you could at least see these instruments in their sort of economic context. So if we can just now briefly look at the terms of the ECAPs, they're found in Core Bundle 3. They are again in materially similar terms, and so we can look at the prospectus issued by LP1, which is at core bundle 350. And here we have 225 million fixed rate CMS linked guaranteed, non-voting, non-cumulative, perpetual preferred securities. It refers to the subordinated guarantee and the fact that application has been made to list preferred securities on the Luxembourg Stock Exchange. If one looks at the summary of preferred securities and subordinated guarantee, and in particular page 894, there is a provision for the ranking of the preferred securities and the rights upon liquidation. And then on page 895, eligible investments, the proceeds raised by the issuer, i.e. GLP1, of the preferred securities will be used by the issuer to purchase the subordinated notes.
Sorry, where are you?
This
Page
is page
895.
Yeah.
Oh yes, eligible investment. Yeah.
Yeah. And the subordinated notes will be issued by UK Holding, i.e. PLC, and will have a maturity of 30 days. And subordinated notes are defined at 900, page 900, in the same way as defined in the limited partnership agreement, explaining that they're fixed rate CMS linked subordinated notes originally issued on the floating date.
Yeah.
So we can now look at the terms of the sub-notes issued by PLC, and they're found also in volume 3, tab 46 to 47. So they're all materially the same, except for one. They're all materially the same. So we can have a look at tab 46, which is the issue by LP1, to LP1, sorry. And so there we have 225 million of fixed rate to CMS linked subordinated notes due 2035.
This is what the judge called claim D. Is that right?
Yes, yes. And you can see halfway down the page that application has been made to list the notes on the Channel Islands Stock Exchange. And then if one moves forward, you can see that the definitions, terms and conditions of the notes, and there you have excluded liabilities, means liabilities, that's at page 795, which are expected to be, and in the opinion of the insolvency office of the issuer, to rank junior to the subordinated liabilities in any insolvency of the issuer. Liabilities means all present and future sums, liabilities and obligations payable or owing by the issuer. And senior liabilities, all liabilities except the subordinated liabilities and the excluded liabilities. And subordinated liabilities means all liabilities to the note holders in respect of the notes, and all other liabilities of the issuer which rank or express to rank pari passu with the note. The definition of liabilities, excluded liabilities, and senior liabilities is the same as in the subdebt, which we'll come on to look at. The difference, and we say, as you have seen from our skeleton, the material difference is the definition of subordinated liabilities. And then we have the status and subordination clause at clause 3, which provides that the notes, that's at page 797, that the notes constitute direct, unsecured and subordinated obligations of the issuer and claims of the note holders against the issuer rank pari passu without any preference among themselves. So that's the note holders relating to this issue of notes. The rights of the note holders in respect of the notes are subordinated to the senior liabilities, and accordingly payment of any amount, whether principal, interest or otherwise, in respect of the notes is conditional upon. Then we have a provision which is really materially the same as in relation to PLC under the LBHI2 level. So accordingly appears 3 times, and because we're in an insolvency process, payment of any amount in respect of the notes is conditional upon the issuer being solvent at the time of and immediately after such payment, and accordingly no such amount which would otherwise fall due for payment should be payable except to the extent that the issuer could make such payment and still be solvent. And then C, for the purposes of condition 3b above, prior to the insolvency of the issuer, a report given at any relevant time as to the insolvency of the issuer by the auditors, and on or after insolvency of the issuer, a report given at any relevant time as to the insolvency of the issuer by its insolvency officer, in each case in a form and substance acceptable to the FSA. And that shall be in the absence of manifest error and treated and accepted by the FSA, the issuer and the note holders as correct and sufficient evidence of the issuer's solvency or insolvency. So, as I say, those notes were listed on the Channel Islands Stock Exchange, and at page 813 you can see something that at the time of this circular, LP1 had already agreed to purchase the notes, and page 806 refers to the fact that the notes will be issued initially in global form, and 807 describes how the proceeds of the notes are to be used, which is to strengthen the regulatory capital base of the group, to pay off existing loans and for general corporate purposes. So, and as we've seen, these notes were purchased by LP1 with the proceeds of the issue of the ECAPs, the prospectus that we've just looked at. The PLC subdebts are found at volume 3, tabs 43 to 45. We only need to look in detail at the first one. Interestingly, they're for the same amounts as in relation to the LBHI2 subdebts, 4.5 billion, 3 billion, and then 8 billion. I don't know why that was particularly, obviously, like those figures. So the first sub-debt agreement, as I say, is at tab 44. I don't think we need to look at it in any real detail because it's in exactly the same terms materially as there are slight differences, but I think for our purposes they're in the same terms as in relation to the LBHI2 subdebts.
You want the one at tab 44? You started off at 43, but I don't know which one you want.
43.
43.
Yeah.
And these are all claim C.
These are all claim C. And at page 755, you have the definition of excluded liabilities, which I say is the same as claim A, and also we see exactly the same definition in claim D, same definition of liabilities in claim D, same definition of senior liabilities in claim D, but the definition of subordinated liabilities is different, and here the definition of subordinated liabilities means all liabilities to the lender in respect of each advance made under this agreement. So whereas claim D, and we'll come on to this in a bit more detail in a minute, but whereas claim D admits of the possibility of liabilities ranking with it on a pari passu basis, claim C says nothing about that. Subordinated liabilities, when one's dealing with claim C, is solely those liabilities in relation to that instrument. So, my lady, my lords, Mr. Beltrami made a number of introductory points about the subordination analysis that the court is required to undertake. And we echo most of those points at our appeal. And in particular, what we say is first, that the task is one of contractual interpretation and contractual application. Second, that the instruments all have to be interpreted according to their words. Factual matrix is largely irrelevant. Firstly, because, as I think my Lord Justice Lewison observed, these are negotiable instruments where the scope of the factual matrix is attenuated in any event. And further, the fact that the instruments under consideration were created to raise funds to provide regulatory capital, in our submission, takes the task of interpretation nowhere in circumstances where it's common ground that no one within the Lehman organisation ever gave any consideration to where these instruments rank between themselves. The judge at first instance found at paragraph 161 that Mr. Miller's evidence was not legally relevant for the purpose of construing the LBHI2 subnotes. Likewise, we say Mr. Miller's evidence is not legally relevant for the purpose of construing the PLC subdebts and the PLC subnotes. So,
is there perhaps a tension between your point that the factual matrix is largely irrelevant on the one hand, and your reference to the fact that no one within Lehman's gave any thought to relative ranking?
Well, it means that there are no, if you like, extraneous facts that one can take into account for the purposes of construing the particular instrument, because if no one gave any thought to it, we are left with the language.
Oh, I see. It's a sort of negative point.
Yes. Right. Yeah. And third, we echo Mr. Beltrami's submission that Rule 1412 of the insolvency rules is not, as I think LBHI would like to persuade you, is not some sort of principle of construction. We say that the rule only applies where construction runs out. There may be, at the end of the day, a very thin veneer or layer between when you can construe the parties to have agreed a pari passu ranking and when you can't, the construction doesn't take you any further because there is just a complete circularity, a continuous loop. But our submission is you have to carry through the construction exercise first and don't, which I think my learned friend Mr. Phillips would invite you to do, don't immediately go to a pari passu conclusion applying Rule 1412. You may reach a pari passu conclusion, and we say that's possible, but we say you can do it with construction. You don't have to just leap for Rule 1412 as providing the answer. My Lady, my Lords, GP1's grounds of appeal are in Volume 1, Tab 12. They're very short, and it's readily apparent from those grounds that our appeal is essentially that the judge erred in not giving full consideration to the words of the instruments being construed, and specifically the subnotes. Put shortly, the subdebts do not, in terms, expressly provide for any other debt ranking at a pari passu level with them. The subnotes do, in terms, expressly provide for debts ranking at the same level as them. And the oddity of the judge's conclusion, and that's at paragraph 356, that conclusion was that that definitional difference between the two instruments made no difference to the outcome. The outcome being that of a pari passu ranking. And he reached that conclusion even though neither instrument C nor instrument D expresses itself in terms to rank pari passu with the other, and the possibility of a pari passu ranking is only acknowledged by the terms of one instrument, claim D, the PLC subnotes, and not the subdebts. Further, although the judge expressly found in paragraph 356 of his judgment that claim C is subordinated debt and is not expressed to rank pari passu with the notes, he overlooked that claim D admitted the possibility of another claim ranking pari passu without there being any expression of such a ranking in the competing instrument. And then, somewhat extraordinarily, having found that claim C is subordinated debt and is not expressed to rank pari passu with the notes, he then went on to find that claim C did indeed rank pari passu with the notes. So in short, what we say is that a key part of the judge's reasoning as to why the instruments do rank pari passu is that they do not rank and are not expressed to rank pari passu. And we say that this is a very strange result, derived, we say, from the cursory attention that the learned judge gave to the question that he posed at paragraph 356, which is claim C a liability of the issuer ranking or expressed to rank pari passu with the notes? And he answered that question in only 2 lines in paragraph 356. He said, given that claim C is subordinated debt and is not expressed to rank pari passu with the PLC subnotes, this definitional difference makes no difference to the outcome.
There's a bit of now you see it, now you don't know, isn't there? Because let us suppose that, leaving aside the terms of the instruments, 2 claims do rank pari passu. The definition of subordinated liabilities in the notes says, well, if they do rank pari passu, they don't, because we're subordinated to them. So it's a very odd concept, isn't it? On the one hand, they do rank pari passu, and on the other hand, they don't.
Well, we say that claim C doesn't rank pari passu. That's the whole point.
Well, yes, but suppose that there was a claim which did rank pari passu
Yes.
with the notes.
Well,
According to the literal interpretation of the definition of subordinated liabilities, it wouldn't.
Well,
But it does.
no, because the definition of subordinated liabilities is both expressed to rank pari passu and does rank pari passu.
But that's the point. If it does rank pari passu, how can it be subordinated?
Well,
How can the notes be subordinated to it if it does in fact rank pari passu?
Well, they wouldn't be in those circumstances. The notes wouldn't be subordinated.
But that's not what the definition says.
But it's necessary to also look at the other instrument. So, I mean, if for example, in this case, D admits of the possibility of a pari passu ranking, but actually when you construe C, that doesn't admit of a pari passu ranking, because the only subordinated liabilities under subject C are those under that particular advance. And the only time that the pari passu ranking comes in is when you have to consider the subdebts, the individual subdebts together. And what breaks the circularity, and we accept that, what breaks the circularity in that event is the statutory rule of pari passu. But as we'll come on to explain, we say that the pari passu statutory rule doesn't actually have to be invoked in construing the debts and the notes in this case.
Well, I understand that. If the instruments themselves show a relative ranking, then you don't get to Rule 1412.
Yes.
I understand that.
I mean, equally, Rule 1412 is part of the background to the whole question of construction.
Yeah. Yeah. Yes.
I mean, I'm slightly puzzled as to why you say it's not. I know it's not a principle of construction, but surely on any view, it's a relevant. I mean, highly relevant part of the background against which all these instruments are created.
It's relevant when you get to the point where you can't construe the instruments any longer. You run out of rope, as it were.
Well, why is it only relevant at that point? I mean,
Well,
I quite see it provides a time break when you get stuck. But why? I mean, it just might. I mean, you're placing a lot of stress on the difference between. I mean, I quite understand why, between the difference of the two definitions of subordinated debt.
Yes.
But if it's really just pointing to something which is a commonplace, namely the default rule anyway is pari passu ranking, then does it really bear all that weight?
Well, if you let me develop my argument, you'll see that there is, in relation to the pari passu wording of D and where we come out to as to where C sits, there is perhaps a very, very thin, paper thin difference between electing for the Rule 1412 and construing it in the way in which we say it can be construed. But we still say that that's relevant. When you come on to C, I mean, one has to have a consistency, and when you come on to C, there is no consistency with the result. We say that D ranks above.
Thank you.
What we say, as I say, is that the judge really didn't grapple with or explore the fact that the two instruments are different. He just said that it makes no difference. And what we say is that if he had grappled with the language, he would have concluded that Claim D must rank above Claim C. But before we get on to the language of Claim C and Claim D, it's necessary to remind ourselves that in construing subordination agreements such as these, a borrower's agreement with its creditors can only identify where the creditor is to be placed in the waterfall. That the creditor can't relegate another creditor lower in the waterfall if the latter creditor has not agreed that outcome with the borrower. So where a borrower agrees with two different lenders, where in the waterfall they rank, there are three possible outcomes as between those lenders. And we set that out at paragraph 33 of our skeleton. First, claim X may provide that it ranks somewhere below claim Y in the waterfall. Claim Y, in turn, may provide that it ranks somewhere above claim X. And in those circumstances, there will be a consistent statement of ranking across the two instruments, and there's no difficulty. So in that instance, Y will rank above claim X, because they both independently agreed with the borrower where they should rank. The second example is that claim X may provide that it ranks somewhere below claim Y, but claim Y doesn't say that it's to be subordinated to claim X. And this was the judge's principle 2 that he identified at paragraph 198 of his judgment, where he concluded that claim A ranked below unamended claim B. In that case, there's still no inconsistency. X treats Y as senior, Y doesn't treat X as senior, and both those statements can be true if X ranks behind Y. There's no need to break any circularity or resolve any inconsistency in that case, because the terms of the instrument dictate the outcome. And then the third possibility is that claim X may provide that it ranks behind claim Y, and claim Y says the same thing about X, and that's the position that we've seen in relation to claims A 1 to 3. There's a straight inconsistency. The propositions can't both be true, and that's where you have to bring in a way to break the circularity, and Rule 1412 does it. My Lord Justice Lewison was asking on Monday about what tool is available in the law's armoury to deal with that inconsistency or circularity, which is caused in the third example. There are 3 candidates, and we say that the first 2 don't work, and the third is to be preferred. The first option is the default rule under 1412.
First one is default rule.
Yeah, well, the problem with that solution is that it begs the question. The 2 instruments are only subordinated to the same senior creditors once it's been decided that the other instrument is not to be treated as a senior creditor for its purposes. And in this context, I should address a comment by my Lord Justice Henderson, who cautioned against referring to the default rule because the rule reflects the starting point rather than the end point. And my Lord is, of course, correct, but it must be recalled that it's common ground in this case that there has been some degree of subordination in all these instruments. The pari passu default rule that otherwise applies in an insolvency has therefore been displaced to some extent, and certainly between these instruments and the general body of unsubordinated creditors. The question is therefore, at what point does the contract run out, so that one has to revert to that default rule? The second option is to treat the subordination provisions as ineffective between the 2 instruments when they present inconsistent results. But as my Lord Justice Lewison put it on Monday, the problem is that they are not ineffective, they are too effective. It's the effectiveness that leads to the impasse problem. If they were not effective, they would not be a problem. And treating them as simply ineffective, therefore again seems to beg the question of why they are ineffective. And so the third option that we would commend is a policy one. It was a point that we ran below in the context of a slightly different debate, which arose following the circulation of the draft judgment. The concern there was that the solvency conditions, if they were to be given a separate life, might prevent payment of any dividends under the instruments, even when they were otherwise due. And our policy argument is this. In a winding up process, it's necessary for the company's assets to be distributed so its affairs can be wound up and the company eventually dissolved. And as a matter of policy, the parties can't by contract evade the operation of the bankruptcy laws. I mean, that's Lord Justice James in Ex parte Mackay. It wasn't in the bundle, my lord, but it is now in the bundle of authorities at tab 85. But I think probably it's generally accepted that that's the principle. Lord Cross, in the majority of the House of Lords, and we may want to turn that up, that's at bundle authorities 5, tab 87. Lord Cross in the House of Lords in British Eagle.
5 tab 87.
Tab 87. At page 779E, Lord Cross said that British Eagle then points out that even though there may be nothing in the Companies Act which deals expressly with a case of this sort, the court can always refuse to give effect to provisions in contracts which achieve a distribution of the insolvent's property which runs counter to the principles of our insolvency legislation, and he cites Ex Mackay. So he records with apparent approval the submission that the court can refuse to give effect to provisions in contracts which achieve a distribution which runs counter to the principles of insolvency legislation. Now, of course, those principles include the distribution of a company's assets pari passu upon a winding up. And at 780F, Lord Cross rejected the submission that such a power is limited to cases where the party's dominant intention was to evade the statutory scheme and therefore disregarded the contractual mechanism for the clearinghouse arrangements then in issue because they had to yield to the general liquidation. That's at 780H to 781B. Now, while subordination provisions per se are not now considered necessarily to fall foul of those principles, there's no suggestion that those principles do not continue to be good law. So, if the effect of the parties' contractual bargain is that neither can submit a proof in the insolvency until the other one has, and that any more junior creditors can't be paid either, that would be an agreement in our submission that even inadvertently prevents the proper operation of insolvency rules and should not be enforced to that extent. In that event, the rules of pari passu distribution will be applied to prevent a situation arising whereby the affairs of the company can't be finally wound up because of an impasse, and the company can't be dissolved because of an impasse created by the contracts made by different parties with the same insolvent debtor company. So the application of the pari passu rule in that instance is not applied because the pari passu rule automatically applies in that instance, but it applies because without applying that rule, the company's affairs can't be finally wound up. So it's a policy-driven solution. So,
yeah, I mean, it's not easy. It's not entirely easy to understand the juridical basis for this. Let us suppose that a loan is made on the terms of one of the sub-debt, at its inception, there's nothing wrong with that. Nothing at all. Perfectly legitimate method of subordinating the debt to other liabilities. And were the borrower to enter insolvency, the court would give effect to that clause. The problem only arises because another one comes along with exactly the same subordination provision.
Yes.
So it's not a case, the sort of British Eagle case of an agreement trying to circumvent the insolvency regime, because neither of them do. I mean, it's the interaction between them that causes the problem.
But that's why we say it's inadvertent.
Yeah.
And then there's no deliberation about it. It just, as things have panned out, because there's two agreements that create this circularity, if the company's affairs are going to be finally wound up, there has to be a solution found. And the solution is to
Disapply.
Yeah.
So it's inevitably an extension of British Eagle.
Yes, although British Eagle is wide enough to encompass the submission that we're making. I mean, the two agreements won't be void, but they're just unenforceable to that extent. They're not void, they obviously have effect, but they can't be enforced or they can't be enforced so that a payment is made because of the circularity. So, and that's why we say the policy solution is the right one. Because
So effectively, I think that means the judge was right, but missed one step in the analysis.
Yeah.
Because once you've disapplied the subordination provisions, then Rule 1412 must take over.
Yeah. But once you've recognised that they're unenforceable between themselves. So, my lady, my lords, with that framework in mind, I'm going to now turn to the instruments in this case. And before looking at the instruments individually, I want to address you on the point that was made by both Mr. Phillips and Mr. Beltrami about simple contractual subordination versus contingent debt subordination. This was addressed by us as ground 2 of our grounds of appeal, where what we said is that the judge erred in concluding that the subordination clause contained both the simple contractual subordination provision and a contingent debt subordination provision. I think we all agree that something went wrong there. But we submit that on a proper construction of the subordination terms in both instruments, they comprised a single contractual subordination term, and that the word accordingly means no more than consequently, or how I read it, it follows. It's describing the consequences of the subordination provision at the beginning of the clause. So, as with the case of Claim A, what is either side of the word accordingly is the same. Once you've identified who the senior creditors are, one knows who one needs to take into account for the purposes of meeting the solvency condition. So, moving on from that point, the first question is, where does Claim C, we were looking at Claim C in tab 43 of Volume 3, page 756, where does Claim C rank itself? So we've looked at the definition of liabilities, subordinated liabilities, senior liabilities and excluded liabilities. So clause 5.1 contains the subordination provision, and clause 5.1 provides that C's claim is subordinated to senior liabilities. C's claim is a subordinated liability, which I've already addressed you on, is defined as all liabilities in respect of each advance made under this agreement. So, under the terms of C's agreement with PLC, a debt under some other instrument can't be a subordinated liability, because the only liabilities comprised in the definition of subordinated liabilities in C's claim are those liabilities created by C. More specifically, Claim D is not a subordinated liability because it is not a liability in respect of the advance made under Claim C's agreement with PLC. So, if Claim D is not a subordinated liability as a matter of construction, Claim D is either a senior liability or an excluded liability as defined in C's agreement with PLC. Senior liabilities in Claim C are all liabilities except subordinated liabilities and excluded liabilities. And excluded liabilities in Claim C are relevantly defined as liabilities which are expressed to rank junior to subordinated liabilities. Now, pausing there, my learned friend Mr. Phillips on Monday proceeded on the basis that an instrument can only express itself to be junior to another if it refers to it in terms. We do not accept that premise. For example, an instrument which contained an absolutely unequivocal statement of subordination to all other debt would be expressed to be junior to all that other debt, even without referring in terms to any particular other instrument. And similarly, we would say that a debt which has expressed itself to be subordinated to everything but a preferential share is expressing itself to be subordinated to other debts which do not so peg themselves to the bottom of that level of the waterfall, even if the debt that subordinates itself to everything but a preferential share doesn't refer to those other debts. Although, for the sake of argument and to make it simple, it's convenient first to consider the analysis as if that premise was right, that you've got to refer to the other debt. In other words, we're going to proceed for now on the basis that an instrument can only express itself to rank junior to another if it refers to the other instrument.
Well, what do you mean by refers to?
Well,
you mean by identifying the parties or by identifying a category?
The category. We mean expression in terms. So on that basis, and still from the perspective of Claim C, the liabilities of Claim D are not expressed to rank junior to the subordinated liabilities. Because, first of all, Claim D doesn't refer to Claim C at all, which was your point, my lord. Thus, Claim D is, pursuant to the terms of Claim C, not an excluded liability. It doesn't express itself to rank junior to the subordinated liabilities. So, according to the terms of C, D is not an excluded liability. So C, according to its own terms, is subordinated to D. And it's now necessary to look at the terms of Claim D to see where D ranks itself. And that provision we've already looked at is at clause 3, and relevantly, at page 797, if you want to look at it. And relevantly, clause 3A provides the notes, i.e. the notes which are the subject matter of that note issue, constitute direct, unsecured and subordinated obligations of PLC and the rights of the note holder against PLC rank pari passu among themselves. So those are the notes involved in that issue. Then it goes on to say that the rights of the note holders are subordinated to senior liabilities, and payment of any amount is conditional upon the PLC being able to pay its liabilities in full, other than the subordinated liabilities, excluding obligations which are not payable or capable of being established or determined in the administration, and excluded liabilities. And I said before, the definitions of senior liabilities, excluded liabilities in Claim D are the same as for Claim C. Claim C does not express itself to rank junior to D. So we know from D's perspective, Claim C is therefore not an excluded liability. However, the definition of subordinated liabilities in Claim D is different from Claim C. We've seen the definition. It's all other liabilities of the issuer which rank or are expressed to rank pari passu with the notes. So within that definition of subordinated liabilities are 1, those claims which rank pari passu with Claim D, or 2, those claims which are expressed to rank pari passu with Claim D. Now, Claim C does not, in express terms, express itself to rank pari passu with Claim D. However, even though Claim C is silent on the point, Claim D does provide for the possibility that an instrument could rank pari passu in fact with Claim D. So Claim D doesn't exclude the possibility of Claim C ranking pari passu with Claim D, although C has not expressly provided for that outcome. So at this point, from the perspective of Claim D, we've whittled the position of Claim C down to 2 possibilities. Either Claim C is a senior liability, or it ranks pari passu with Claim D. But the outcome of treating C as a senior liability is, we say, not one that is sensibly or really available. For Claim, as a matter of construction, because for Claim D to treat Claim C as a senior liability would result in both Claim D and Claim C being senior liabilities to each other, creating the endless loop that we saw with Claims A to A3. So, sensibly and reasonably, one wouldn't wish to construe Claim D as having that effect unless there was no other alternative conclusion. But there is an alternative conclusion. It's not the only option available from Claims D's perspective, but it's a sensible option because Claim D can accommodate Claim C on a pari passu basis at the subordinated level, a pari passu ranking which is expressly provided for in D's definition of subordinated liabilities.
So you have to read the definition, though, as referring to a claim which, but for this definition, would rank pari passu, don't you?
Well, no, because what you're looking at is you're trying to rank other subordinated debt according to where D sees them in the waterfall. So, there, as I explained, there are 2 options. Once one's got rid of C not being an excluded liability, there are 2 options. It would be a senior liability or it would be a subordinated liability. And logically and reasonably, why would anybody, as a matter of construction, say, well, C must be a senior liability if it produces the endless loop that that is created in relation to A1 to 3? Why would one opt for an endless loop if one could actually produce the same outcome on the terms of D's agreement with the borrower? And that we can, because D's agreement with the borrower admits of the possibility of a pari passu ranking at D's level. And that, we say, is a more sensible outcome because it avoids the endless loop. C has already ranked D as a senior creditor, so you don't have to worry about C. What we're talking about is where D would rank C. And it doesn't make logical sense as a matter of construction for D to rank C, or for the court to rank C at the level of a senior creditor, which creates the very endless loop, which is so deeply unattractive. We only opt for we only are driven to an endless loop when there is no other solution. And on this occasion, there is another solution. D expressly provides for the possibility of an alternative debt ranking at a pari passu level with it.
Well, then you get into the now you see it, now you don't, because having recognised that possibility, D now takes priority over something which would otherwise have ranked pari passu with D.
Well,
and that's why I suggested to you, you might have to read the definitions as if it said, which but for this definition would otherwise rank pari passu.
Well, it's not a now you see it, now you don't situation, because we've already established that C, on its own terms, has made D a senior liability. So we're only talking about where D is considering it should rank C. And D, by allowing C to rank pari passu, is not subordinating itself to C. I mean, the result of that construction is that claim D is a senior liability according to the terms of claim C's agreement with PLC.
Yeah.
But claim C is a subordinated liability according to the terms of claim D's agreement with PLC. As I say, why should, as a matter of construction, the court conclude that claim C is a senior liability according to the terms of claim D's agreement with PLC, when that will create an endless loop, when there is an alternative solution, which is claim C being subordinated liability, pari passu with claim D. And because claim C has already elected to treat claim D as a senior liability, claim D therefore ranks for payment before claim C. And what we say is that this conclusion is consistent with the judge's principle articulated at, second principle articulated at paragraph 198, and which I addressed you on when I set out three possible outcomes. The first outcome being it's made absolutely clear, X makes absolutely clear that it ranks somewhere below Y, Y makes it absolutely clear that it ranks somewhere above claim X. There's a consistent state of ranking, no problem. And the second example is where claim X provides that it ranks somewhere below claim Y, but claim Y doesn't say that it is to be subordinated to claim X. And that is the second principle that the judge identified at 198, and that is the principle that we say applies in this case. Here, instrument C subordinates itself to a senior debt, D, but the second instrument, D, does not subordinate itself to C because it does not treat C as a senior liability. The consequence is that C ranks behind D. In short, claim C's terms contain an unequivocal expression of subordination. C's terms do not say anything about being subordinated to a level which is pari passu with another instrument. But the same is not true of claim D. And as a consequence, we say that claim C sees claim D as a senior liability, but claim D doesn't see claim C as a senior liability. LBHI's complaint at paragraph 5 of its skeleton is that because we argue that the pari passu wording in the PLC subnotes means that claim C and claim D may result in a pari passu ranking, claim C cannot rank junior to claim D. But this is to ignore the fact that when we acknowledge that the wording of the PLC subnotes, that's D, admits of the possibility that claim C may rank pari passu with claim D, that is looking at the position from D's perspective. The relevant conclusion, and the only relevant conclusion, is that D doesn't treat C as a senior liability, because to do so would be to create a circularity. And as I say, why would you opt? Why would you deliberately create a circularity when you don't have to, when there is another provision in the instrument which avoids that result? So D doesn't treat C as senior because C may rank pari passu. But D can't dictate where C ranks by reference to it, only that C does not rank ahead of it. And in order to find out where claim D ranks from C's perspective, it's necessary to look at the wording of claim C. And claim C unequivocally subordinates itself to senior liabilities, but not to liabilities which are expressed to be junior to the subordinated liability.
No, I understand that bit. So you say whatever may or may not be clear about claim D, it doesn't express itself to be junior to claim C, or
and therefore, as regards claim C, D must rank senior.
Yeah. If you express yourself to rank pari passu with something else, you're not ranking yourself junior.
No, exactly. And that's not the same when you're looking at it from D's perspective, because D admits of the possibility of a pari passu ranking. And so and we say that paragraph 29 of LBHI's skeleton is wrong. Paragraph 29 submits that the judge's analysis of the PLC priority dispute was correct because it was rooted in the fundamental similarity between claim D and claim D. And I hope I've demonstrated to my lady, my lords, that the similarity was not fundamental. The key provisions were different, and unless we just throw up our hands and just ignore the fact that the provisions were different in this case, then it's necessary to look at them and to try and give meaning to them. But the judge did not try to see where the differences led him as a matter of the construction of the language. On the contrary, extraordinarily, we would say, having concluded that claim C was not expressed to rank pari passu with claim D, the judge concluded that claim C and claim D did rank pari passu, and that's what's so strange. I mean, if claim D didn't express itself to rank pari, how do you get to a pari passu ranking? Secondly, LBHI submitted that the judge's analysis was correct because they say the interaction between the subordination provisions resulted in a meaningless outcome. But as we've explained, the interaction between claim C and claim D doesn't result in a meaningless outcome. If you apply our analysis and our construction, claim D ranks ahead. And LBHI is also wrong at paragraph 37 of its skeleton argument when it describes GP1's argument that claim C is a subordinated liability from claim D's perspective, because it does in fact rank pari passu with claim D. That's not GP1's argument. GP1's argument is simply that from claim D's perspective, it will not, doesn't have to, treat claim C as a senior liability, and that's because it can accommodate it on a pari passu basis. And so therefore, it doesn't subordinate itself to it. Whether or not claim C in fact ranks pari passu is not an outcome which is in D's gift. Where claim C ends up ranking requires a consideration of claim C's terms and then a comparison of the results. LBHI is also wrong in its submission at paragraph 39 of its skeleton that it's not open for GP1 to hedge its bets by reference to a tentative pari passu ranking without committing itself either way. Again, and I'm sorry if I'm repeating myself in different ways, but again, LBHI misunderstands the purpose of this iterative exercise. Claim D doesn't have to commit itself to ranking pari passu with the subdebts. However, the fact that claim D on its own terms can tolerate a pari passu ranking with the subdebts has the consequence that claim D, unlike claim C, doesn't treat claim C as a senior liability. And that's what we're saying at paragraph 21, spot 2, subparagraphs 3 and 4 of our skeleton. And LBHI's skeleton is no answer to it.
Can I come back to a point I was putting to you rather prematurely about half an hour ago, which is I'm a little troubled by the weight which this possibility of a pari passu ranking is being asked to bear, bearing in mind that that's anyway the default position, and of course one can always envisage another instrument which just expresses itself to rank pari passu with something else. I mean, that's really just a statement of the obvious. So just admitting that as a possibility, how can that really be sufficient, as well, to make all the difference?
Well, it's not, doesn't make all the difference, but we're left with claim D with two options: a senior liability or a pari passu ranking with D as a subordinated debt. And all we're saying is that as a matter of construction, why would D opt for C to be a senior liability, which would create this endless loop?
Well, in fact, that brings on back to pari passu again, doesn't it?
Well, no, well, it doesn't have to opt for being a senior liability,
No.
because on its own terms, D has if you like, a get out. D allows for the possibility that claim C can rank itself as a pari passu liability with claim D, and claim C doesn't have that effect.
You're just saying that it's there is potential for it.
Yes.
And it's the more business capacious
Yes.
construction. That's
Yeah.
what you're saying.
Yes.
So I'm to try and put it in simple language so even I can
Yeah.
understand it. You have an instrument under which somebody lends some money to a borrower, and the lender says, "Well, I will subordinate myself to everything except that which ranks pari passu to me." And then another lender comes along and says, "Well, I'll subordinate myself to everything." And that's really what that's where you get to.
That's where you get to. Yeah. And that's not so extraordinary. I mean, that's just a function of the terminology. C was happy to go to the bottom of the pile, but D admitted of the possibility that it didn't go to the bottom of the pile.
Yeah, you can pay your butcher's bill before you pay me, but otherwise I'll take the divvy available to all your creditors. And then your dressmaker says, "Well, I'll come last."
Yeah. Well, it's taking me a bit out of my time, but if we can, one of the possibilities that we posit in our skeleton is a claim F. Claim F is a bit, as you described, my lord. Claim F comes along, and claim F expresses a flaw to the degree of subordination, namely that it doesn't want to be subordinated to the same degree as claim C. Such a term would not offend the principles of insolvency law, as claim F would not be seeking to achieve a better outcome in an insolvency than it would have achieved but for the existence of subordination provisions. Prima facie, claim C is already more junior to claim F, as claim C is expressed to be junior to everything. And it wouldn't contradict the terms of claim C, because claim C on its terms always falls to the bottom of the pile, save in respect to debts which are expressed to be more junior still, which claim F is expressly not. Now, on the other hand, at the same time as claim S is saying, I don't want to be subordinated to the same degree as claim C, claim F could express itself to be subordinated to all unsubordinated creditors of PLC, but to rank pari passu with claim D. That again wouldn't offend the principles of insolvency law as they relate to subordination, because claim F would simply be relegating itself down the order of priority it would have enjoyed but for such a term. And claim F wouldn't be impermissibly to promote itself, nor would it cause any problems with the terms of claim D, because the PLC subnotes expressly accommodate other debts expressed to rank pari passu at that level. So you could have claim F that says, I want to rank pari passu with claim D, but I don't want to fall to the level of claim C. Claim C has already said, I want to be subordinated to everything except that which is excluded.
So F is not pushing C down.
No,
C
no.
has already taken its position at the bottom of the pile.
Right, I think we've got that point.
So we say that because claim F can express itself without contradicting either claim C or D or the insolvency principles as ranking ahead of C but alongside D, that means that D must rank ahead of C, using that sort of hypothetical example. Now, LBHI seek to answer this hypothetical debt point at paragraphs 49 to 50 of their skeleton. They posit a claim G, which expressly ranks itself junior to claim C and senior to claim D. Our submission is that claim G doesn't provide any answer.
Sorry,
to the
which,
example
I'm sorry,
that we give.
which paragraph of
This is paragraphs 49 to 50 of LBHI Skeleton
Yeah.
at volume 1, tab 19, page 303.
Yes, yes, yes.
So they seek, LBHI seek to answer this hypothetical debt point. They posit a claim G, which expressly ranks itself junior to claim C and senior to claim D. But claim G in our submission doesn't provide an answer to the example that we give of claim F. If claim D is senior to claim C and claim C is junior to claim D, claim G's terms have clearly resulted in a meaningless expression of subordination, and it would be a matter for the court to determine whether G should be ranked junior to C or above claim D in that instance. However, the fact that claim G, the terms of claim G, creates difficulties in ranking G in that instance does not result in our hypothetical claim F not serving as an analytical tool to test the ranking of claim C and claim D as between themselves. And that's all it is. That's all claim F is. We're using it as an analytical tool to test the ranking. We say that it's actually an appropriate analytical tool because it demonstrates that C does rank below D. This is a convenient point to relax the expression in terms approach and to rerun the analysis by looking to see whether C or D do express themselves to be more junior to the other despite not referring to each other in terms. And this is a much shorter exercise because of the analysis that we've already done. The conclusion that we draw is that C still ranks below D. We start again with claim C. It's subordinated to claim D unless claim D expresses itself to be more junior still. To consider whether claim D expresses itself to be more junior still, one needs to consider the terms of claim D, and that's not reading the instruments conjunctively, but looking at the terms of D when C requires one to. The problem is that when asking what claim D expresses about its ranking, it's obviously necessary to refer back to claim C, because claim D asks, amongst other things, whether claim C expresses itself to rank junior. Now, absent some logical tool to cut through the exercise, there's a never-ending jumping back and forth between the terms of the two instruments. But there is a logical tool to cut through the exercise, which effectively imposes an answer we came to on the express in terms approach. That's to recognise that when one asks whether from D's perspective C is expressed to rank junior, there can only be two answers, yes or no. If the answer is yes, then C is not a senior liability from D's perspective, and D is not subordinated to C. If the answer is no, then from D's perspective, that might be because C is pari passu or senior. But as we've seen already, it would be absurd to posit the senior outcome, as that leads to circularity, which would revert to pari passu. From D's perspective, the worst case outcome is that C ranks pari passu. It expressly permits that outcome. So why, as a matter of construction, would one not be drawn to that outcome? So when C asks whether D expresses itself to be junior to C, the answer is no. D views C as at worst equal to it. It does not accommodate an outcome where C is senior. And it doesn't depend on where you start. Start from D. D asks whether C expresses itself to be junior or not. Again, via the same process, D concludes that C either expresses itself to be junior or pari passu, but it will therefore either be an excluded liability or a subordinated liability, never senior. Again, to construe claim D in a way that treats claim C as senior is to impose a circularity in the outcome, which claim D does not require there to be. So, short but sweet, perfectly formed, I would say. The main thing to bear in mind, my lady and my lords, is that there is an inconsistency, but C ranks D above it.
Yeah. Yeah. I mean, your main complaint about the judge is he didn't dive into the definition.
No.
Yeah, he just ignored it.
Yeah. And the definition must mean something.
Yeah. All right. Thank you, Ms. Hilliard.
Thank you.
Who's next? Mr. Lane.
My lord, Deutsche Bank's case is that on a proper interpretation of the two sets of subordination provisions, like the then period, the PLC subnotes have priority. That case arises only if the lordship does not accept Ms. Hilliard's textual analysis and argument. So the premise of my case, which I think is the same premise that Mr. Phillips has, and indeed was the basis on which the judge approached it, is that the two sets are circular, two sets of provisions are circular, and on their face, the circularity needs to be resolved.
So we are to assume that they each rank each other senior.
That's right, read literally.
Yeah.
So my lord, the structure of my submissions is that I'm going to start with a brief overview of my case, and then I'm in your lordship's hands. I can either address the issue of permission, because Mr. Phillips takes a point that I don't have permission to advance this argument, or I can deal with the question of permission after I've developed the argument. I'm entirely in your lordship's hands.
Well, I think we'd better see how the argument goes.
So,
But I think you're trying to rely on it simply as an aid to construction
I am.
of the instruments.
That's right. So the short...
Whether that's permissible because it's particular background material which wouldn't necessarily have been known to the reasonable reader is a different question, but I understand that that's the way you want to deploy it.
Indeed, my lord. The short point is that the way the judge approached this argument in the first instance was to address the question of the party's subjective intentions based on the evidence he heard. That was not a case that the bank ever advanced. It was the evidence given by a witness, I accept that, but it wasn't advanced by us in opening or indeed in closing. Our case was and remains that objectively in the terms of the debt structure, one can see in this circumstance an intention which aids construction. It's an objective intention, it's nothing to do with...
Well, yes, I understand that, but this is prayed in aid of the priority of claim D, which is the notes, tradable. So you've got to get your particular dividend stopper agreement into the
tradable notes.
Yeah.
I understand that. And I understand, and I'll address that. It's a difficulty I accept, but it's one that I think on the facts of this case may be that exceptional case where you can do that even though the instrument is a tradable note.
Right.
So the starting point is that the judge did not in fact ever engage with this argument. And that was surprising because he actually said no authority was cited to him. And in fact, the same line of authorities that we have cited in our skeleton of this appeal was cited both in opening and in closing. And in essence, what we are saying is that there is a clear and objective indication as to what the parties would have intended had they turned their minds to the point. And that's apparently the contractual debt structure. And I'll come on to develop that, but can I make 4 points in brief summary by way of an overview, and then I'll develop it. So the first point is that the PLC sub-debt was an intra-group liability that was settled by way of book entry. In contrast, the PLC sub-notes were part of a back-to-back funding structure involving securities which you've been shown briefly, the ECAPs. And the ECAPs, just so your lordship knows, is an acronym for Enhanced Capital Advantage Preferred Securities.
Say that again. Enhanced.
Enhanced Capital Advantage Preferred Securities. And the crucial point is that these were issued to external investors, including Deutsche Bank, by partnerships controlled by LVHI. My lord, I'm raising my voice to outdo the scaffolding.
Yes.
Too loud.
Sorry about that.
And the short point is that the payments due under the ECAPs could not be paid unless PLC made the regular payments due under the PLC notes. And I'll show you that. That was the funding structure. And so effectively, PLC's payments under the sub-notes funded the distributions under the ECAPs. The second of my 4 points is that under the terms of the ECAPs, LVHI undertook not to pay any dividends or repurchase any stock if any of the regular payments were not made under the ECAPs. That's the dividend stopper. Your lordships note that's addressed in our skeleton at paragraphs 42 to 45, and I'll come back to it. Now, the judge described the dividend stopper in an unchallenged finding at paragraph 366 sub 6 of his judgment.
356, did you say?
Sorry, 366.
366.
Subparagraph 6, which I'll show you in a moment. And what he said was that it was a commercial incentive on LVHI to ensure that PLC could pay all sums payable under the sub-notes. And he recognised at subparagraph 5 of the same paragraph of his judgment that there was a strong commercial incentive because triggering the dividend stopper would have been extremely damaging to the Lehman Group. And the third point is that under the express terms of the PLC sub-debt, and this is the point we've been addressed on this morning, all other subordinated debt had to be either senior or junior. And what we say is that having agreed by the express terms against the background of Rule 14.2, that provision, the only possible conclusion is the parties intended to change the outcome that would have applied under Rule 14.2. So the debt was either junior or senior, it was not to be pari passu. And that must then be seen from the parties' intentions. The fourth point, and this is one point where Mr. Phillips and I agree, that the subordination provisions in the subdebt and the subnotes were intended to and did operate in a solvent situation. And that was at the time of every payment under each instrument. So for PLC to make regular interest payments under the subnotes to fund the payments due under the ECAPs, PLC had to be able to satisfy the solvency condition to that payment. And so when interpreting these instruments, the court should have in mind the possible commercial consequences of any possible interpretation in a solvent situation, not just an insolvent, because that we submit to give a real clue to what the parties would have intended had they addressed their mind to the point. And what we draw from those 4 points, which I've developed, is that, first of all, each of those points would have been known to the parties to the PLC subnotes. That's PLC as the issuer and the LBHI controlled partnerships as the subscribing noteholders. And that may be relevant to the fact that this is being implied into the notice as to who the noteholders were and what the purpose of the structure was, which I'll come on to. The second point one can take from it is that, therefore, from the perspective of the reasonable, objective person in their position, what they would have intended had they thought about the relative priority of the subnotes and subdebt was, first of all, as I've said, the intention appears to be that the subdebt would rank either senior or junior, those being the only options on the terms of it. And we say they would plainly have intended the subnotes to rank senior, knowing that they funded external liabilities, the failure to meet those liabilities triggering a disastrous scenario, the Lehman Brothers. And in particular, had they been ranked pari passu, PLC's ability to pay the subnotes, even outside insolvency, would have been competing with its very substantial intra-group liabilities to LV Holdings under the debt. And just to put that in context, the total amount that could be drawn under the debt facilities was 3 billion and 12.5 billion, with a floating interest rate that could vary significantly. So why put at risk the triggering of the dividend stopper by putting it into competition with that sort of internal subdebt? So that's the case in a nutshell, and obviously I have to develop that and make that good. Now, just standing back and looking at what the judge did, the judge, rather than seeking to resolve the conflict in circularity by seeking to determine as a matter of contractual interpretation which of the 2 sets of provisions prevailed, effectively, we submit with respect, just abandoned any process of construction. And he almost accepts that in his judgment. He says no authority was cited to him, and he accepts it's a fairly novel approach. And we submit that the one thing the judge should not have done was that, even if he'd reached a different outcome, he had to go through a process of contractual interpretation. And the reason he appears to have done what he did was a misunderstanding that the pari passu rule was some form of default. But that's just not right. And as you've heard from both, I think, Mr. Beltrami and Ms. Hilliard, the pari passu rule is simply a rule of distribution. It provides for the claims of creditors with the same right to payment to be treated equally, but it doesn't determine whether the 2 creditors have the same right to payment in the first place. So it's only a that it operates unless there's a contractual agreement. And I think Mr. Phillips accepted that. It's not a default, it's not a tiebreaker. The contract trumps. You have to say there's no contract before you get to that position. And you have to interpret the contract before you can get to that position. And what we say is that the judge properly interpreting the contract, whether or not he followed the approach that we're advocating, the one thing he did, which was, we say, unacceptable, was to ignore the express terms. And that's because we say that he arrived at the one conclusion that's precluded by the parties' agreement, namely that the sub-debt couldn't rank pari passu with any other debt issued by PLCs. I think there's Phillips was developing that point. So we say to take that as the starting point on the express terms, his result, or at least the way he went about it, was wrong, and we submit that that's a clear indicator, and then the question is junior or senior, and we say that can be discerned not on the words, but looking at what the parties would have intended. And the line of authorities we rely upon is the Bromerin line, my Lord, I'm going to take the court to my Lord Justice Lewison's book, which sets out all the relevant extracts in one case. And essentially, as the court will know, this is where the parties on their face haven't actually provided with a scenario. The court then, I think as it's put in one of the cases, doesn't just throw up its hands. It looks to find what the parties would have intended as best it can. That's not to say that the court has to rewrite the contract. It's not to say that the parties' irrelevant subjective intentions can come into play. And it's not to say that the court can always do it. But at least it's a process one should try to engage with, and that's what we're suggesting to the court. And we're saying that the judge's approach should actually just be set aside if he didn't engage with this process, and actually he appears to have analysed this argument on an entirely wrong basis. So can I show your lordship quickly the authorities, and then I'll come back after lunch to develop my
Just a thought goes through my mind, bearing in mind that Mr. Beltrami yesterday was describing the details, as it were, as mechanism. I mean, there are cases which say that where the party's machinery fails, the court can step in. That's not quite the same principle as working out what the parties would have decided if they thought about it, but it's maybe a related principle, a sort of Sudbrook and Eggleton type case. I'm sorry, I may be another red herring, just as bad as Kemp and Neptune Concord. It's a thought. Anyway, where are we going?
Well, can I go first to my skeleton?
Yeah, oh yes.
Paragraph 28 to 32 is where the principles are set out. For your lordship's note, I don't think we should turn it up. This was all set out at first instance, and one can see that in the first volume of the supplementary bundle, tab 11, at paragraph 166 onwards. So it was all there at first instance.
Sorry, I was looking at the wrong skeleton. Which paragraphs?
28 to 32 of the appeal skeleton.
Yeah.
And that's in the full bundle, tab 18.
Yes.
And the key propositions are as follows. First, where there is an event or circumstance that is not contemplated in the parties' contractual agreement, judging from the language of the contract, if it is clear what the parties would have intended, the court will give effect to that intention. And that's the citation from Lord Newberger's judgment in Harvard and Britain, which follows on the Bromerin line. And obviously we emphasise the word would have, because obviously the premise of this is that the parties did not. The second point which follows on is the question of whether or not the event or circumstance was contemplated is to be judged from the language of the contract. So it's not concerned with whether the parties subjectively failed to contemplate the relevant circumstance. What matters is that the court is faced with a situation for which objectively the contract fails to provide, and that is why the court is engaging in this exercise. And I'll just pick up that point because my learned friend Mr. Phillips mounts an attack on the application of the Bromerin principle. 19, that's paragraph 68, he says you've got to look at whether the particular event was unforeseen at the relevant time, namely when the contract was made, which we agree with provided that's an objective exercise, not a subjective. And if you look at paragraph 69 of the skeleton, the test changes to whether the event was unforeseeable, which we say is not the right test. So the fact he predicates his submission on saying, well, obviously the parties must have foreseen, or it was foreseeable that the FSA standard form point he makes, and that this scenario could have happened. That's not the right test. On the face of it, the test is, did the parties cater for the situation, and if the words don't appear to suggest they did, that's what they would have done. So that's why we say the principle applies here.
Now, what strikes me as odd, it's just my own reflection, is that the FSA didn't see this problem when they were promulgating their standard form.
I think that's because it doesn't matter to the FSA how subordinated debt ranks amongst itself. And that's, I think, why. I think as long as it's within the tiers they accept, and they don't mind what happens in the rank at the bottom, that's the understanding. The third point, my lord, is if the principle is engaged, then as an objective exercise, the court's task, as this court well knows, is to identify from the terms of the contract and the admissible factual matrix what the parties would have intended. And obviously the judge made various comments about what the admissible factual matrix was. Now, I'm not trying to pray in aid facts and matters known from discussions that were had or that type of factual matrix. I am actually looking at part of the back-to-back funding structure. So the ECAPS is a back-to-back structure with the notes. And that's the matrix I'm looking at. So can I just ask your lordships to look at Authorities Fund 4, tab 73, which is an extract from my Lord Justice Lewison's book. So maybe unnecessary, my Lord Justice Lewison's book, but this sets out the extracts from various cases and points, and it may be helpful if after lunch I can just show you the Munich case, which is the last case I cited. And it may be that you prefer just to cast your eye over the
Yeah,
two
you needn't read it aloud. How much do you want us to read?
Well, if you could cast your eye over the Bromer in principle,
Yeah.
And then over to page 2.919, the Nagel case, which I think my Lord Justice Henderson is familiar with. And then
Well, I was
finally
at
the
one
Munich
stage,
case.
yes. Thank you.
going to show you either now or after lunch, I mean, the case, the Munich capital case, which should have been added to the Lordship's bundle, but happened to buy.
Well, should we do this after lunch? I imagine it's going to take more than a couple of minutes. 2 o'clock.
Bye.